SJC-13078, Commonwealth versus Mark O'Brien.
Okay, Attorney Essington, whenever you're ready.
Thank you. Good morning. May it please the court, Catherine Essington on behalf of the defendant Mark O'Brien. I'd like to start with the first issue in my brief. Trial counsel was ineffective and made a manifestly unreasonable decision in waiving an involuntary manslaughter instruction. The instruction must be given if any view of the evidence, any reasonable view of the evidence would support it. Here there were multiple ways that the jury could have found Mr. O'Brien guilty of involuntary manslaughter. First and foremost, they could have found that Mr. McKenna died as a result of going through the window, as a result of a misdemeanor assault, or that he died as a result of the reckless and wanton conduct of the burglars in breaking into his house at night.
What were the injuries?
What were the injuries?
What were the injuries to Mr. McKenna?
Well, obviously he had a fatal injury to his arm that was a transection of an artery as well as some major veins. Beyond that, he had scalp wounds.
What was the cause of death?
The cause of death was his bleeding out. Primarily, I would argue, from the injury to the arm, but the medical examiner did testify that the scalp injuries were a contributing cause.
Okay, so we got injury to the arm, and what other injuries?
He had bruising in various places throughout his body, I think on his face, on his torso, and perhaps arms and legs. I can't exactly recall, but there was bruising in various places in his body.
How would all that be consistent with wanton and reckless conduct? I mean, this was a pretty savage beating. I mean, how would a reasonable view of the evidence here support that?
Well, again, his cause of death was going through the window, I would submit. And while it does appear that there was a struggle and he sustained injuries in that struggle, there was no direct evidence that Mr. O'Brien participated in that assault. And furthermore, I would argue that the jury could have found that there was a misdemeanor assault with respect to what happened just before his going through the window.
Can I ask something more fundamental? I'm sorry, Justice Gaziano.
He was a joint venturer. There was a joint venture theory, right?
That's correct, Your Honor. But
You want us to separate out his involvement, but he's a joint venture, and then separate out one injury from a cluster of injuries?
well, with respect to the first part of your question, I would argue that under pursuant to Brown, that the jury has to find malice with respect to each co-venturer.
No, you have to show shared intent.
Yes, the shared intent and shared malice, essentially.
Right, and you don't think this is at least third-pronged malice?
I would argue that Mr. O'Brien, the jury did not have to conclude that Mr. O'Brien participated in any kind of a felony assault here. There was no DNA or fingerprints of Mr. O'Brien in the house.
Well, that just argues for the reasonableness of counsel's decision to lay the defense on O'Brien wasn't the third actor.
Right.
Right. So, but in connection with asking for a jury instruction on involuntary manslaughter, you'd have to at least agree with the proposition that O'Brien was the third actor. And once you're there, all of those injuries inflicted to the victim, I don't understand how you can separate them from O'Brien if he is in fact the third actor.
Well, with respect to the first part of your question, I'm not arguing that counsel's theory of the case or his primary theory of the case was unreasonable, and I don't think the court has to find that. But I don't think it's unusual at all for defense counsel to argue alternate theories here.
Right, but in the alternate universe, where O'Brien is the third actor, I don't see the injuries here, to Justice Gaziano's point, or at least explain to me how the injuries to this particular victim are consistent with lack of malice.
Well, again, Your Honor, I would argue that obviously there was a struggle. We know that, but we don't know.
A vicious beating, really, because it's the head, the face, the torso, and the bleeding out from the arm and the head.
Well, again, the arm injury was not caused by any beating. That was caused by his going through the window. And I would argue that the jury, again, the standard really is important here. Is there any reasonable view of the evidence from which the jury could have concluded that?
So your reasonable view of the evidence would be, yes, O'Brien was the third party, but he was not involved in the beating.
That's correct, Your Honor. I don't think there was any direct evidence that he was involved in the beating. Again, there was no forensic evidence tying him to the inside of the house. There was...
No, but on this theory where you're asking for the instruction, he was in the house.
Sure, the instruction would assume a sort of fallback, what I would characterize as a fallback position, that if the jury found that he was in the house, that they could reach this manslaughter conviction.
We have a lot of cases where there are these types of beatings or a type of injuries like this, and we say, well, there was no grounds for involuntary because it was at a minimum third-pronged malice. What's your best case in a cluster of beatings or injuries type case where we've said what the proposition you urge us to take?
Well, I guess I would argue, sorry, need a minute. You know, I don't know if I have a specific case, and I'll get back to that, but I think this is different from a lot of those cases. In that this was, first of all, an unarmed robbery, and there was no clear intent shown to cause the death
But they
of,
came back
of
on,
the
they came
victim.
back on both. They came back on atrocity and cruelty and felony murder, correct? Post-Brown felony murder.
Yes, yes. I'm sorry, they came back on extreme atrocity and cruelty, which again, I would argue is partly as a result of the prosecutorial misconduct in this case, in terms of arguing that that they stepped on him as he was bleeding out, in addition to arguing that leaving him to bleed out was malice or extreme atrocity and cruelty, and I don't think the case law supports that at all.
Well, if you look at Castillo in the atrocity cruelty factors, this certainly is sufficient, right?
I disagree that leaving someone without preventing them from seeking aid is in and of itself extreme atrocity and cruelty.
But just think, if you look at what we said in Castillo, right, and we modified the Hunter standards, I thought that this case lines up fine. There's no sufficiency argument, and you didn't raise the sufficiency argument on atrocity and cruelty.
Yes.
It's different from
Yeah,
what you
but
argue
I would argue.
on closing argument, of course.
Yes, I would argue that contributed to that verdict. I mean, and again, I would just stress the standard here, which is the evidence must be viewed in the light most favorable to the defendant. If there's any reasonable basis to support the instruction, then it must be given, and it's reversible error not to do so. Again, we have a situation which is unusual, I would argue, in this case, that the jury could have reasonably found that he did not die as a result of any beating by the defendants, that he died because of a freak accident, essentially, of going through the window and severing an artery, which caused him to bleed out.
But you said that it was both the arm and the injuries to the back of the head, right? And
the medical examiner testified that the back of the head was a contributing cause, but I think there's substantial evidence that Mr. Mr. McKenna lived for a substantial period of time after the blows to the back of the head. And she acknowledged in her testimony that that likely wouldn't have killed him, that the bleeding could have slowed down, that was just sort of a contributing factor in terms of blood loss.
That doesn't help you, though. The fact that he's suffering for that extended period of time doesn't help you when saying it was a freak injury, when he's beaten, the arm injury, then he's beaten with a fry pan, right? Dent in a fry pan, that's kind of severe.
Well, I would respectfully disagree that it doesn't help me. I think it does show that injury, the fry pan injury, which was, again, it was arguably severe, but it was an aluminum fry pan. There was substantial evidence that he walked over the fry pan and threw out the house after sustaining that injury. So that was not a
I'm sorry,
direct...
after sustaining which injury? The arm injury or the fry pan?
The frying pan injury.
Okay. And the frying pan was dented?
Correct.
Okay.
And I'd like to turn, before I run out of time, to the claims of prosecutorial misconduct in this case. Ronald King, in this case, who was a very important witness, gave blatantly false testimony with respect to what benefits and payments he had received.
Defense counsel was able to draw out, though, that this had been a cooperating witness with the Boston Police Department for years, right?
Yes, he was.
And that he had received compensation throughout those years.
Yes, but again, that's a different county, first of all, and that it was those payments were in exchange for his drug work for them, essentially.
I thought the $930 was disclosed.
It was disclosed, but I think under Ware that the prosecutor has a duty to correct that. This court had said that very clearly in Ware, even if defense counsel is aware. And that duty was not performed here. In addition, he gave blatantly false testimony about whether he'd received money for prescription medication. He failed to disclose cash given to him for daily living expenses and other items amounting to several $100s. And the jury just never heard any of that based on the prosecutor's failure to correct that testimony, which was blatantly false.
Well, assume that we give you a little bit of that because it was cross-examined, maybe not the full extent of what the consideration was to the cooperating witness. Some of it was cross-examined and it was brought out. So it wasn't as if the jury had no idea that this witness got something for their testimony. But let me go to the more important issue that I'm struggling with. This was unpreserved, right? This was
Correct.
not, this, okay, so now get to the prejudice part for me, because that's, to me, even if I concede that, that's the part that I'm struggling with. Show me how, with an unpreserved claim like this, where there was some cross-examination, it wasn't like it wasn't brought up at all, how you meet the prejudice part.
Sure, Your Honor. Again, the importance of this witness cannot be overstated. This was the only witness who put Mr. O'Brien in that house. There was zero forensic evidence putting him in that house.
There certainly was circumstantial evidence, though, that put him in that house.
I would say there was circumstantial evidence that put him with Mr. Ferguson, and there was forensic evidence that Mr. Ferguson was in the house.
Because there was a glove that had a particular brand found in the house. That same branded glove was found in the defendant's car.
Yeah, and that was an important point on it. This is why I wanted the prosecutor to correct a misstatement in her brief on this issue. Mr. O'Brien had a pair, not one, but a pair of similar gloves, which are very common work gloves.
All right, but I mean, I'm pushing back on this notion that nothing else put Mr. O'Brien in that house. Okay, so whether it was a pair or that, we're not saying that it was the second part of the pair. There was a mechanic's glove in Mr. O'Brien's car. There was a mechanic's glove in the house.
There were 2 mechanic gloves in his
Sure,
car.
sure. But you also have evidence that the police seized his car, the car was clean, there was cleaner in there, there was occult blood that was found in the car. So I'm struggling to see how important this witness is to the fact that he was in the house, that there was evidence that he was in the house.
I would respectfully disagree that there was evidence in the house. Again, this was an extremely bloody scene, and there was no forensic evidence, unlike his 2 co-defendants who left DNA or had the victim's
So King
blood.
was definitely an important witness, right? But the defense counsel did impeach King. I guess the question on prejudice is really, or substantial likelihood of a miscarriage of justice, is whether this additional monetary contribution to King really undermined the ability of the defense counsel to further impeach King in the situation where the defense counsel actually had the information in his back pocket. So you could just explain to me how that further inability, apparently, to impeach him.
Sure. I would stress again that this was different from the situation where King worked as a paid informant for the Boston Police Department. Again, this was...
Wasn't that the theme of the defense counsel? It was like this was a paid liar, I think is what they said in closing argument, that he had for years been an informant for the police.
I certainly would agree that that was a theme.
So how does this additional $900 really further that in the sense of creating a substantial likelihood of a miscarriage of justice?
Because it was direct payment for his testimony in this case.
Okay.
And I think that is a crucial distinction between his work for the Boston Police Department as a paid informant. It was an exchange for his testimony in this case. And again, he testified that my client, Mr. O'Brien, confessed to him that he was the 3rd person in this house. There couldn't have been more damaging testimony than that testimony. Again, I think that his testimony was a key part of this case. And again, there was a long, if you go through the transcripts, there was a long discussion or motions and hearings about whether defense counsel would be allowed to get in the fact that testimony that King gave in another case, in a cold murder case in Suffolk County, had proved to be unreliable. And ultimately, he was not allowed to get that in front of the jury. But again, that prolonged debate about whether that testimony would be allowed or not, which the Commonwealth opposed, of course, shows how important Ron King's credibility was in this case, and discrediting him was a key part of the strategy in this case.
Can I ask you to address the sequence of the injuries and the evidence or lack thereof?
Yes, Your Honor. Again, my second claim of prosecutorial misconduct, which was raised sua sponte by Judge Locke, was the prosecutors arguing that the blows from the frying pan occurred after the victim went through the window, while he was bleeding out, that they were intending to...
Didn't you just argue that to us?
I'm sorry, no,
Did you just tell us that?
I did not I don't think I said that the blows to the frying pan occurred after he went through the window. I don't think that makes any sense
I thought you
in
said
terms
that
of the evidence.
The fatal wound was the accidental thing from the window, and then he was beaten.
If I did, I misspoke. I don't believe I did, but no, the fatal arm injury.
I know it's difficult to sequence injuries, right? And lawyers do it all the time. So you're saying this was prosecutorial misconduct to sequence logically the injuries?
Yes, because there was no evidence to support that theory, and in fact, the evidence plainly was contradictory to that theory. And in Mr. Ferguson's case, in the co-defendant's case, the prosecutor conceded that the view of the evidence that made the most sense was in fact the reverse, that the frying pan injury happened before. And the blood on the frying pan, including the blood on the handle of the frying pan, clearly showed that the victim had walked over the frying pan while bleeding, and that there was no evidence to support that occurred after he was laying on the ground, after he'd gone through the window.
Wasn't there some, I guess, you know the record better than I do, so tell me, what is the difference between the impact splatter and the cast-off splatter? Because there was some testimony by the blood expert about impact splatter, which seemed to suggest or support an inference that the sequence was as argued by the prosecutor.
There was some testimony about impact splatter, but the blood expert did not testify about sequence, nor did the medical examiner. But I actually think it supports the opposite view. The only, I think, impact splatter that she testified about was in the hallway right outside the master bedroom. The frying pan was found in the master bedroom. The window that was broken was in the spare bedroom.
If it's arguable, that's all it needs to be, right? It's just a reasonable inference from the evidence.
But it has to be reasonable, and I would argue in this case it was not reasonable based on all of the evidence, and the prosecutor acknowledged as much in the testimony, in her statements in the co-defendant's trial, Mr. Ferguson's trial. Unless there are any other questions, my time is up, I see. Thank you.
Thank you. Okay, Attorney Kiggin.
Thank you. May it please the court, Christine Kiggin, representing the Commonwealth, Plymouth County District Attorney's Office. I was trial counsel for this case as well as the co-defendants. I'd also like to acknowledge the presence of the trial team in the front row here for all four of these trials. There were 3 defendants. There were 4 trials because one of them mistried.
So can you then address why apparently there was a concession in the Ferguson trial that the sequence, it was not reasonable to argue that the frying pan injuries happened after the cut on the arm through the window?
Respectfully, I wouldn't agree that it was a concession. I believe what I stated was that we don't know the order of events. And as I stand here today, we don't know the order of events.
Okay, so what made the argument reasonable in this case?
It was reasonable inferences from the evidence.
Because you don't know.
Because we don't know. It was a chaotic.
There was nothing that you were relying on in terms of the blood splatter expert. You were just, we don't know whether it happened before or after, so I'm just going to argue that it happened after because that's more extreme and cruel.
Absolutely not.
Okay, so what was the argument then?
Well, as you asked earlier about the impact spatter, there was testimony. The Commonwealth was limited in their blood stain experts' testimony. The judge limited in the trial what exactly they could testify to in terms of opinion testimony. However, they were able to give expert explanatory testimony about the difference between the 2 spatters, and the impact spatter being what it sounds like, that it's more consistent that there was spatter coming from a violent impact upon the subject. There was plenty of that evidence. The house was replete with blood evidence. There was smear evidence. There were footprints all over the house. There was blood from the master bedroom all the way down to the kitchen where he was found. But there was
but I'm
impact.
just going to ask you to focus on the sequence. So it's your position that it was the impact blood stain splatter as opposed to the cast-off splatter that supported the argument that the frying pan injuries happened after the window injury.
I think it was many things. I think that's just one
What
of them.
else besides the impact
Well, the
splatter?
location. So the arterial bleed caused the most bleeding. And to be clear, Dr. Mindy Hull, the medical examiner in this case testified that the cause of death was not just the bleed out from the arterial bleed under the arm. It was also those injuries from the back of the head, which inferentially came from the frying pan beating.
Right, so just sticking with the sequence of the injuries. So there's the impact splatter.
So where I'm going with this, Justice, is that there was blood, copious amounts of blood in the master bedroom where the frying pan was found. That permits a fair and reasonable inference that after Mr. McKenna sustained the arterial bleed to his arm, given the amount of blood on that master bedroom floor, that the jury saw those pictures, that Mr. McKenna was in that master bedroom bleeding out with those copious amounts of blood, and that's where the frying pan is found. And the frying pan is coated in blood, and there is spatter on top of the frying pan, as counsel pointed out in her brief and argued, well, counsel speculated on her appellate brief that must have meant that the frying pan came first. But there's no way of knowing with the blood that's on the floor in the bedroom. That suggests that Mr. McKenna was in the master bedroom bleeding out, and then the frying pan's found in that location, in the master bedroom, and there's spatter on top of it. So there's nothing to suggest that the frying pan was used first. It's more reasonable, I would suggest, with the amount of blood that's found on the floor in the master bedroom, that it was used in the master bedroom, given the amount of blood, not the cast-off and not the impact, as you're asking. I'm suggesting the amount of blood and the placement of the frying pan. The cast-off and the impact is all over the house, Judge. It's in the hallways. It's in the area of where we believe he was struck with the frying pan. But Mr. McKenna is found, his final resting point is in the kitchen. But the amount of blood is not any less in that master bedroom, which suggests that after he was bleeding out from the window, the arterial bleed under the arm, he was in that master bedroom, which is where the frying pan's found. So that is why I suggest that it is a fair and reasonable inference to suggest that he was struck with the frying pan after he was bleeding out from the window.
Is that obvious?
I don't know that that's obvious, and that's what
But isn't that what you said?
I didn't say that. I said that it's a fair and reasonable inference.
Oh, I mean, at closing argument, isn't that what you said? That he was obviously bleeding out?
He,
And I suggest to
that
you...
he was bleeding out? Oh, yes.
And I suggest to you is evidence of malice.
Yes. Obviously bleeding out, the spurts, yes. I mistook your question as to was it obvious as to the sequence. No, as to him bleeding out, Your Honor, absolutely it was obvious that he was bleeding out.
Because there's blood standing in the bedroom floor.
All over the bedroom floor.
Right.
And the walls, and the thresholds of the doors, all along the hallways leading to the second bedroom.
Which would be consistent with an arterial bleed.
Yes.
Yes.
So in that sense, absolutely, it was obvious he was obviously bleeding out. And so I think the big issue in this case is malice, and I argued it in my brief, but this is not an involuntary manslaughter case. Commonwealth versus Fritzmeier tells us that the law of the Commonwealth is that a battery not amounting to a felony, where someone there should be an awareness of a risk of death, could be an involuntary manslaughter under a wanton and reckless theory. These facts couldn't be any further from a wanton and reckless theory.
It's two different things. There's battery leading to death, which is
Yes.
involuntary manslaughter, and then there's wanton reckless conduct, which is involuntary manslaughter.
Correct.
But either way, it
But
doesn't fit the bill. under
Either
your
way,
view.
the Commonwealth's position, Your Honor, is that it does not fit the bill. The evidence, there were over 200 or 300 exhibits in this case, 160 of them photographs of all the blood in the house and of the victim's injuries. Counsel was asked during her argument about the injuries. This wasn't a case, Your Honors, where Mr. McKenna sustained a bleed under his arm and had a few scrapes and scratches. I suggest he was covered from head to toe with bruises, abrasion, scratches, underneath his lip, all around his forehead, forceful blows to the back of the head, which caused bleeding and contributed to his death. The evidence and the reasonable inferences showed that there was a beating of this man, 3-on-1, and the 3-on-1 is because of the footprints. There are 3 distinct sets of footprints, and Trooper Bankston in this case did a diagram. He diagrammed out, there were more than 27, but he diagrammed out 27 separate shoe prints and showed them to the jury all over the house. And then in and among them, there were the barefoot impressions. All of this leading to a fair, reasonable, permissible inference that these 3 individuals were attacking the victim about his house as he bled out. The footprints in the blood, as I stated, were distinct, and they were in close proximity to his barefoot prints. The evidence and the reasonable inferences displayed a kind of risk that could only lead to a finding of malice. And as I said in my brief, there's simply no version of the facts in this particular case that would support a finding that the victim was subjected to a battery not amounting to a felony. In the co-defendant's trials, a different judge heard largely the same evidence. He declined to instruct on an involuntary manslaughter. I suggest what trial counsel did in this case was he was candid. When Judge Locke asked him, what is the evidence that would support an involuntary manslaughter? He answered candidly, I don't see evidence of it. And what he did instead was he focused reasonably his defense on Mr. O'Brien not being there. And he did a good job of that, I suggest. I looked at his closing argument, and from beginning to end, there was a consistent theme that Mr. O'Brien, they can't show that Mr. O'Brien was there. He started with the neighborhood observations, where he said that one of the neighbors saw a black vehicle in the victim's driveway, consistent with the co-defendant, Michael Masquerito's
Counsel, I
car.
don't mean to interrupt you, but it is a natural segue into the discussion about the informant, right? So the counsel, as you just alluded to, really focused on nothing puts him there, and really the central piece of evidence or witness that puts him there is the informant. Do you concede that all of that stuff didn't come out and should have come out? The $922 or whatever the amount was?
The actual dollar amounts, correct, did not come out. And the $50 in asthma medication did not come out. It was, I questioned him, trial counsel questioned him. Again, what about those medications? He didn't recall. And I cited to Commonwealth versus Moore in this case, that where this court found that it is not up to the Commonwealth to impeach their own witness, because there are occasions, which I suggest this is one, where a witness, due to the passage of time or confusion, just simply makes a mistake. I disagree. The Commonwealth disagrees that Ron King got up and gave blatantly false testimony. The key in the Moore case and the other cases that focus on this kind of situation was defendant provided with all of these materials? And he 100% was. I included that as a footnote, and I don't know if I put it in a record appendix, but there was early on a lot of discovery regarding this individual. There was a lot of pretrial litigation over what was going to be produced, and then we re-argued what was admissible before Judge Locke. And trial counsel had every bit of the impeachment evidence, right up to the $30,000 plus that was paid to him by the Suffolk County DA's office when he worked for them as an informant. And I would suggest in this case, Mr. King wasn't an informant. And I want to make that distinction, because I know that counsel called Mr. King in brief, and in Your Honor as well. He's a fact witness in this case. Yes, he's been an informant his whole adult lifetime and potentially made a career out of it. The jury heard all of that. All of that was brought out by Mr. Murphy was absolutely ample impeachment evidence for the jury to assess Mr. King's credibility. I suggest that a $50 worth of asthma medication that I think he just either didn't know, because those things happen, they don't even know what they're getting sometimes, they just know that their expenses are getting taken care of, and they don't know all the details. Whether he just didn't remember it or he just didn't know it, I don't think that $50 payment of asthma medication was going to sway the jury.
Did the impeachment also, did Mr. Murphy bring out that he got basically living expenses?
I don't know that he did. I asked him what he was receiving. I asked it very openly. according to the transcript. I said, "Are you receiving any benefit for testifying?" And he answered with a, "This is not a benefit," because it was emotional for him. On cross-examination, he agreed that he received payment for a hotel room, a one-way airline ticket to come to court to testify. On redirect, the prosecutor asked him if there were any other monies that were paid. So again, counsel's,
What was his answer to that?
No.
he said $12 to change his phone number. Because I'm going to just suggest to you, to Mr. King, that was more important than the $50 for his asthma medication. And that's my opinion, coming from someone who's in the midst of dealing with these witnesses. But again, the case law recognizes that witnesses have frailties with their memories, whether it's confusion, passage of time, or they just didn't know, they just weren't aware. And but the prosecutor, me on redirect, I asked him. So the suggestion in this case that I failed to correct Mr. King's blatantly false testimony, I specifically got up on redirect when Mr. Murphy didn't bring out all of that because I knew that there was more, and I asked him that question, was there anything else? And he came up with the $12 to change his phone number. And then Mr. Murphy, I would suggest it then prompted Mr. Murphy to say, wait, he didn't get into everything else. And then he got up on recross and he said, did the Commonwealth pay for any medication? And King answered, not that he was aware of. I'm not sure that, first of all, I'm not sure that the court would have permitted a redirect. There are some judges who only allow us to do that once. But the point is that it was asked, it was re-asked, it was crossed, it was recrossed, and that was what we got. And I suggest that there's a far cry between the mistake maybe he made in his testimony and blatantly false testimony.
Can I ask you about the all or nothing strategy? Because it seemed like counsel actually did ask for sudden combat, jury instruction, and absence of mistake or accident. So it didn't seem like counsel was actually pursuing an all or nothing strategy.
I agree based on the instructions that he was asking for. And, but I have some thoughts on that sort of go outside the record because there was a lot of pretrial litigation about the theories in this case, the theories of, and the burdens, the suggestions of the charges in this case. But when you look at the record, that's exactly what he argued. Again, in his closing argument, it was all or nothing. It was.
Did Judge Locke decline to instruct on voluntary manslaughter?
Yes, that's correct.
What about accident?
There was no instruction on it.
Okay, so he had lost the jury instruction battle.
On voluntary, at least, and he withdrew.
Involuntary.
And he withdrew involuntary.
He did. He withdrew it. But again, I think it was a moment of
But he couldn't ride those two horses because he didn't get an instruction on voluntary.
correct. I think what counsel in the brief talked about, though, was earlier on in the trial, he had said that he wanted an involuntary. But he changed his mind, and I suggest he was candid with Judge Locke when Judge Locke asked him what evidence supports it.
Then he made whatever argument he could on voluntary, and he lost that argument.
Yes, that's true. And for the all or nothing judge, he said no DNA of Mark O'Brien from a blood-stained crime scene. He attacked the credibility of the civilian witnesses, but he suggested other people as third-party culprits, and that was reasonable. So there's this witness, Thomas Gunning, and Thomas Gunning was, for lack of a better expression, the link between the defendants and the victim in this case. He had been in the victim's house, he had seen some things he liked, he was impressed by it, took some cell phone pictures, sent them out to the crowd. Somehow the defendants were exposed to that and came up with the plan to rob him. So it was reasonable to suggest Thomas Gunning as a third-party culprit. Also, Tom Gunning, there was no DNA buccal swab taken from Tom Gunning, so it was reasonable for him to suggest Tom Gunning. He also, in his all or nothing, he said that many witnesses, he sort of mocked the Commonwealth's presentation of witnesses by saying, hey, the first half of this trial, you heard from all these witnesses came in here, they don't even know Mark O'Brien. They've never even heard of Mark O'Brien. That's the evidence that the Commonwealth's giving you. But again, why is he doing that? Because he's putting together an all or nothing, trying to distance Mr. O'Brien from the other defendants in this case and say, you heard from all these witnesses that knew the other two guys. What'd you hear about my guy? He said the Commonwealth didn't show that Mark O'Brien was part of the joint venture, couldn't show the intent that he had joined in the joint venture attack. He pointed out there were 43 separate items examined for DNA comparison, and not a single item pointed to Mark O'Brien. That was a reasonable decision to argue that. He also said, well, look at O'Brien's car. That was the only place where his DNA was found. He suggested Lauren Khalil, the girlfriend of the co-defendant Michael Mascartolo. She testified, and there was some statement that she gave to the police. You don't think I was the other person in the house, do you? Because one of the shoe prints was noticeably smaller than the others. And so he brought that up and said maybe it was these other two defendants, and maybe it was Lauren Khalil, distancing from Mark O'Brien, all or nothing. He suggested that, again, this wasn't brought up today, very important, it wasn't just Ron King and this other circumstantial evidence and inferences that put Mark O'Brien in that house. Lauren Khalil testified that the day after she identified Mark O'Brien in a photo array, showing up at the house with the co-defendant, James Ferguson, and opening up the back hatch of his car and carrying out a big bag. There was at least a big duffel bag of some sort. She also said that she knew James Ferguson. She didn't know the defendant, Mark O'Brien. She said that he was quiet, he kept his head down, but what she saw was a fresh cut under his eye, that it took up almost under his eye. She said it looked like a red rug burn. It was red. That's fairly significant here. And when you pair that up with what Mr. Ron King testified to, that the defendant said to him, I was the third guy, and things got ugly. So it's more than what was discussed earlier as to placing him in that house. That injury to his eye, and him showing up at the scene the day after with this big bag that inferentially was the guns, was very significant evidence. But Mr. Murphy was also, again, in his all or nothing, saying you can't believe Lauren Khalil's testimony about the cut under the eye and the showing up at the house with the big bag in the back of the car, because she's going to say anything she can to save her own skin. He told the jury to disregard her testimony because she was just working for the government. He told the jury to disregard everything Ron King said because he was a professional liar. And he also argued that the cell site location testimony did not put O'Brien in a southern location beyond Weymouth. And it didn't. So that was also a very strong point on the part of Mr. Murphy in arguing for his all or nothing. Mark O'Brien didn't do it.